I have read it, brother. In the morning, I do not want to spoil.
Regarding
What is for the other side? There are two questions. One relates to whether the writ applies, and second relates to whether it will be entertained by a division bench or it has to go to the single bench if the writ applies.
that is single bench.
This is what I also, brother. Is it what bench roster? Let the matter go out of this. Dictate this. Type the order immediately. I'll sign it here.
We clearly list item number 1.
What is this?
My kindly see page annex of 36 at page 147. Lordship had put me a specific query and directed me to obtain instruction whether the authority who has conducted the hearing has passed the order. Because the allegation in the writ petition was that the hearing was conducted by one Sangram Swain, whereas the order was passed by the joint secretary. That is what the. So I have obtained the specific instructions regarding this.
That was a question we put. That the writ petition, the allegation is misconceived or something. You just tell us the straight away.
What has happened, my lord? This Sangram Kesari Swain, special secretary, he conducted the hearing. He prepared the record of notes with his own findings. That was sent for approval to the minister of the concerned department. After approval, Annex 36 is only a communication which was made to the petitioner.
But the tenet of the communication does not reveal that there was any kind of a thing. You may, that is your internal things. You have not disclosed anything.
But this has been
the entire tenet is as if he has heard and he is deciding the whole cause. This is Annex 36.
And since it is approved by the minister,
where is the communication? He should have said
but the
that this order was passed and placed before the minister, the honorable minister. The honorable minister has ratified and accepted it. Now it is being communicated to you.
It only says by the order of Governor D.K. Mahapatra, ex-joint secretary.
So what is this? And that creates a doubt. You may be correct, but there is nothing on record. It comes. Nothing on record that comes.
And another aspect, I have a second submission. So apart from this instruction, the Lordship may kindly see first two paragraphs of that impugned order, Annex 36. It is an admitted case that his lease expired.
I understand, sir. Again, I'm saying you are really trying to convert the court into the armchair of the administrative officer.
No,
is it permissible?
No, my lord. On the question of law, my lord. Only on the question.
That is, I'm talking about a law.
Now,
should the court, you are now saying that the merit has been taken care of, consider the merit. What is there? There is nothing. I understand.
Undisputed fact that he has operated the mines for after expiry of lease under the deeming clause without an environment clearance, which is a mandatory requirement.
Oh, I understand. Then you go and take a decision.
And it was kept idle, and the mines was kept idle for next 2 years. That is why there is a lapsing. And as on date, the State Impact Assessment Authority has also filed a counter affidavit that as on date, there is no EC, and even no EC application is pending with the author.
We are not going to enter into all these aspect of the matter. We are simply concerned with one point. One who has heard must pass an order. A person who has not heard the parties and then pass the order. Is it permissible in law? That is what we say. He may not have any case. It does not require a second thought into it. Let us go to that extent. But still the authorities, if we accept this kind of situations, it will open a Pandora box for all time to come.
Earlier, your lordship set aside that order.
And then you decided whatever you decide. Reject, allow, whatever it is within your domain, you do it. Nobody prevents you from doing or taking a decision. But this is not acceptable, sir. Just imagine a learned judge has heard the matter. Another learned judge who never heard the matter passed the order. Is it a proper way of doing justice?
Mr. Das, you say that you have given this, you have not verified the records. See, by order of the governor.
By order of the governor.
Nothing. My question is not finished. You are saying minister approved. And is it the order of the governor? Please explain. Under the rules of business, let us see. What is rules of business? Get it. How could this additional secretary give you such an information and instruction? If minister approves, can it be governor's order? And you are stating it is proceeding and order. Your heading is proceedings, and you are passing order by the order of governor.
Well, since it's the order of the government,
So it has to be placed
Government.
before His Excellency the Honorable Governor.
lordship, may I request my lord? My lord, may kindly have a glance to rule 11 of the rules of business. Lord.
Yes.
It's rule 11.
Yes. Give me the copy. It does not. We don't have.
I'm sorry, your lordship may have my rule 11.
If minister approves, that becomes
No, my lord.
governor's order. I am yet to learn.
All orders and instruments of the
No,
government.
that is true. That is what is to be done.
So
Which
without
rule?
his knowledge, without his knowledge,
No. Which rule?
The rule 11, my lord. Rule 11 of the rules of business. I think page rule 11.
Understand. But again, the question is because the last penultimate paragraph says that he is a person who has heard and everything is done by him. That is not.
Furnish the instruction.
No, sir.
But my lord, my
Yes, sir.
question, my lord.
Is rule 11. It says that's private. Left.
A judgment, that is the recent Supreme Court judgment, my lord. Here, my lord, if your lordship will find that the last operative portion
regarding issue.
regarding environment clearance, page
That is mandatory. I do not have an inkling of doubts on your stand. Environmental clearance after that common cause judgment has gained a very importance, integral part of it, without which one cannot. But still, I have said that once the adjudication is to be made, it's to be made.
by the
So how can you?
That's just one submission. In this case, the apex court has was the order of the MOF, where the MOF has given a letter that the violation cases shall be processed after paying the polluter pay principle payment. That was passed by the Honorable Apex Court of the plea that post facto approval of the EC cannot be given. After that, your lordship, the direction is the MOF.
Sir, then we'll have to enter into the merit. Can we?
Lordship,
There are another principle. Suppose an administrative authority has not considered anything. Will the court usurp the power of the administrative authority and then pass the order as if the court is an administrative authority? No. The decision of the Supreme Court is that the court should not usurp the power of the administrative authority and then proceed to pass an order. Here it's a case which is a very alarming one, that a person say A has heard the entire proceedings and a person say B has passed the order. What do you say, sir? Tell us, do you approve this kind of a procedure to be adopted? Similarly, if this bench has heard the matter, the another bench will deliver a judgment. What do you say? As a lawyer, tell me.
that is not sustainable.
That is what is the simple thing.
That was part of the order.
Whatever, sir, this is, I can only say it's a irony of the procedural lapses that the matter remained pending for nearly 2 years. Of this could have been disposed of on a day one. On that point itself. Inviting the affidavits. Look. The seminal point involved in the
4 weeks, approximate direct 8 weeks. So that in between, is there will be any kind of communication and other thing?
8.
Item number 2.
These are all in the judgment format. Yeah.
The Lordship, we have already limited the refund amount to the petitioner.
So it has become infructuous.
I have also paid for interest, my lord, in this petition because they have withheld my money.
What is that money?
My lord, Lordship, kindly listen, see my prayer, my lord.
What is that money? What is the nature of the money?
Refund of the excess amount.
Excess amount, my.
So then why will not pay you an interest? You have utilized the amount, sir.
Your Lordship, there were some details which are required from the state government. Your
But whatever be, sir, then why he should be penalized for that? This is your own internal lapses or the gaps. Why litigant will suffer?
More than 5 years, 6 months, my lord, till today.
More than 5 years, 6 months.
5.5 years.
Exactly.
My lord,
5 years, 6 months, how many days?
Yes, my lord, 31/10/2020, my lord, I am entitled to get it.
Pay the interest.
It is specifically,
What is the prime lending rate? Give that. Is there any statutory interest in the rules?
My lord, 24%, my lord.
Oh, where?
24% MC, my mineral concession rules and mineral concession rule to 2016, my lord.
But you have paid for 12.
My lord, I have paid.
24%, sir.
My lord.
I was thinking of prime lending rate as determined by the Reserve Bank of India.
1960 and rule 49 of the 2016 rules. The same rate match.
Is it?
A of the mineral concession rules 1960. 1960. And we have got, my lord, rule 49, my lord, rule 49 of 2016.
Indian Constitution rules.
My lord. 2016. Rule 49.
49.
My lord, payment of interest.
12%, sir.
My lord. 59 is
Not 24, sir. 12% has been substituted way back in 2021, sir.
no, I'm sorry, my lord. 49.
You are saying,
My-
sir, 24%.
But my rules were very short.
No, sir.
I am sorry.
And this relates to which, what? Is it, what is that, the oaths, what is the oath?
Chromate, my lord. Chromate, major mineral.
Major will.
2016 rules, my lord, that the major rules, my lord.
Seen other than atomic and hydrocarbon.
My lord,
minerals.
My lord,
I was thinking in that line, that's why I asked.
my lord, my lord. Obliged.
Yes, sir. What to do, sir? 12%. So you can charge, then you also pay. It's not a one-way traffic, sir. Equity is a two-way traffic. If for their fault, if you can charge 12% under Rule 49, then for your lapses, why you will not pay 12%? That's a statutory one. You have framed the statute. How can you define?
I can't stand and give my notes of the question, but only thing is this: the government there is a process.
These are the procedural. This is your internal mechanism. But the bottom line of the story is that he has paid. He wanted the refund. Refund has been accepted. Then he'll have to pay the interest. You have utilized the money. You have to pay.
49. Kindly see 49. The state government may, without prejudice to the provisions contained in the Act and the rules made thereunder, charge simple interest at the 12% per annum on any rent, royalty, fee, and other than the fee payable. But this is the central government, the state government can charge. Here, the amount which was deposited by the petitioner was immediately transferred to the Consolidated Fund of India. But that the excess amount could not be released because of the communication gap.
Whatever communication gap means, the central government was saying that I do not know whether it has been remitted to a consolidated.
It was immediately
Immediately you made a clarification. They have verified that document and it appears. So once this particular provision is there, then he is in that. Now again the question would be, who will pay, the state or the center? Will you fight?
Well, we have immediately transferred that amount to the.
I do not know. You fight with the central government. You sir.
Why should he stand?
He is entitled. Let him pay. You fight.
As per the statutory.
Two arguments. We are directing the central government to pay, and then giving them a liberty to take an action.
Then may I pray one thing? Because I received instruction about payment. Let's give you one red thing. Then I'll file an affidavit, because if so, then we have to file an affidavit.
What affidavit?
That this amount is remitted such and such date after receiving such and such from the government of such and such date. And also I'll take instruction about the payment of, if they have paid somebody's by delaying payment for interest, we are able to get stand on the.
We are directing you to make the payments, and then if there is anything which the state owes to you, you just charge the state.
State has cleared it immediately, madam. State
You are
Since the government is
your issue.
yes, they are own.
At your level, you sort out.
You have mediation.
Yet who is prejudiced about the getting money, he has got many. Only
It is-
part of
it
interest
is
are taken.
from a left hand to a right hand. Now,
Only one debt Lakshmi gets it. Because there is no statutory provision of law to give the interest.
what are you talking on?
Well, as regard to the payment, then the statute says you have to collect interest.
Correct. See, that is what I'm saying.
Visa will pay interest.
If you can charge an interest, then any excess amount.
Plus,
which is
that part I
will you
know.
not pay the interest? Same way, it's an equitable principle.
Suitable principle, yes. So what I'm saying, man, Lakshmi give a short time because who is prejudiced?
Not a-
Because he is getting his money.
I think that judgment, payment of interest, I have dealt with that issue. I said statutory, no statutory interest, but principle of interest.
Supreme Court judgment. Para 12,
You need a judgment.
12 go ahead. Oh, Punnivar Mania, Punnivar, state of paragraph from paragraph 12.
Paragraph 12.
Yes.
Paragraph 12, my lord. From paragraph 12 onwards.
Restitution, doctrine of restitution.
The restitution is a different
No,
concept.
my lord. Second concept is interest, my lord.
The interest is always there on restitution.
That is compensatory.
2025 volume 7. 7 is 26.
That is compensatory for
My lord.
deprivation.
Oh, no, it is not in case of these natures. These are,
My lord, in this case,
if
my
you
lord.
want that we can make a distinction. That the case of restitution is something different.
No, in this case, my lord, Honorable Supreme Court said that because you have delayed the payment, you are liable to
That
compensate.
I know, but that is
My lord,
what is
this
a
is the-
normal equitable principle.
My lord, this is the principle, my lord, and inserted in this cell. Paragraph 15, my lord, specifically also. 18.
The reference in particular motion.
Fine.
Now, once you have entered into this domain, then I am talking.
Fine.
In that sense, you are referring paragraph 14. There is a judgment.
Fine.
It has to be understood in this way because the example has been given by the judge in Karnataka Bank judgment.
Fine.
What is the main object of the banking system? What the bank does? The bank, who is a, I would say, the accumulator of the depositors' money, not only pays interest to the depositors, but also uses that money by giving or issuing a loan
Right.
and charging the higher amount of an interest. So it is a profit-making organization which makes the profit from the money belonging to another person
Right.
and then runs its
Fine.
show. But here is a case where the government does not utilize that money
Fine.
for any gain. It is really reverted back to the public for their or for the public good
Fine.
or for their benefits, not for earning any kind of a profit from the money.
Fine.
So whether these principles would really apply in the case of such nature. The example is
Fine.
so
So that tender matter,
Fine.
Anupam traders, emanated from this.
it is really an equitable principle that comes.
Fine.
Is not that entitled to a difference in all circumstances. This settlement is on a different
Fine.
Yes, sir, you pay. Money is now with you.
My lord,
The
what
money
I
is with
bring,
you.
my lord, let me give a one chance.
What one chance?
Because my lord, as regard to payment is concerned, who is prejudiced? We'll find out this and what they have cited in the one part, but we'll take proper instruction if
As
there's.
your junior just said that we have gone into the all the
No, they have given a.
data of the data which is there. And we found, yes, money was given to you. Now you will refund it. You have decided to refund that excess amount. No,
Already transferred. Already
the question is of an interest. So
So,
one
we will
is,
not do scope to file affidavit.
one
Already
is undisputed is that the excess money was lying with you.
if he is entitled to,
Undisputed that you have paid back.
but if he is
And it is
entitled,
undisputed that it was lying with you for a pretty long time. So pay the interest. And we will give you a liberty that for a period where the money was not remitted to you, charge. Whatever the excess amount you have paid, you can charge for the scheme. And they will refund.
they are showing that it is a delay of 6 years, but it is not a 6 years because.
Because it was remitted to you within 3 years before.
Yes.
But actual payment was made 6 years before. So it is a state's liability also to you because they have utilized.
Yes.
So you sort out your problem. That is what
That's why I am asking some time. I don't
Sort of
that gives some
he
time.
will be deprived.
No, I will not say that because his amount has already been remitted to them. Only part of the interest will take some time.
Part of the interest, pay for the time being as a nodal, I would say the noble the garment, okay, and then realize from the sticker.
Because I asked my officer to have a revisionary state, and if something has been done in other case, then it will go to dispute straight away. They will settle. Otherwise, they will find out what is the norms and they can.
No, I understand. That's why I'm saying that we will not go into that cost. We will keep it open for you.
They will pay. How you are deputed, how you are paid, how it is. It will be recorded in data.
I think between you.
That's why I'm seeking time, my lord. I'm not.
We are making it very open and very clear. We are making it very open and clear. Don't worry.
Well, there is no difference if Lordship will decide today or after certain time.
You settle your score. Settle your score.
Settle.
You will say that whose liability you can manage.
Second way to we are not the party.
You are not a party.
It is in respect of DML.
DMF and royalty man. Royalty and thereafter, my lord, the lessee has petitioner has applied for the consent to operate and so also the environmental clearance. And the TOR was issued, my lord, only public hearing was awarded, my lord. And while the matter stood thus, my lord, on the 2009, my lord, the Deputy Director Mines Raulkala stopped the mines, my lord, by page 45, Annexure 4, mine. Annexure 4, my lord, page 45. Your Honor, may kindly see page 46, serial number 17 is the petitioner name.
How can you start a mining operation without?
No, my lord, I have not started my.
Clearance to operate?
No, my lord, thereafter the lease was lapsed, my lord. On 15/10/2015, my lord. But prior to that, my lord, the quartz was declared as the minor mineral. Thereafter, I have filed a review application before the Government of India, and that was returned with the remark that the quartz and quartzite was becoming minor mineral. So they have, they do not have the registration, the jurisdiction. I have also filed a review application before the state government, my lord. And I have also filed a written application. I have taken the liberty to approach the state government authority. So, Lordship, kindly state the informed order, my lord, page 118, my lord. 118, my lord. That is the informed annexure 18, the last paragraph. After careful examination and consideration, the state government have been pleased to declare the mining lease for quartz and quartzite mines over, my lord. 105, my lord. 119, last paragraph. After careful examination and consideration, the state government have been pleased to declare the mining lease for quartz and quartzite mines over an area 14.6 hectares in villages.
So it has lapsed.
Lapsed, my lord, lapsed.
Period has expired.
No, my lord, lapsed under the provisions of under Rule 26(9) of OMC Rule 2016 with effect from 6/11/2011, my lord, when the quartz and quartzite was the major mineral. Quartz and quartzite was declared the minor mineral on 10/2/2015, my lord. Your lordship, I have also enclosed that notification, my lord. Your lordship, can see page 66, man. Page 66, annexure 6, man.
What is the provision in this in 2016? Is there any letting and a selling clause? Is there any letting and a selling clause in 2016?
And my lord,
minor mineral declared quartzite. Initially, they entered the major mineral, subsequently declared as minor mineral. That notification in the FPS 66. Now it is but now it was MMDL.
What is it was a quartz was a major mineral or a minor mineral at that point of time?
major mineral. 10/2/2025, my lord, it was declared as major mineral, and now
Yes.
minor. And it once again declared major mineral on 22/2025.
What is the effect of Rule 66 of the governance?
Well,
It talks about the legal process, but what about this? So,
This is a mining rules. This tells for the grant, my lord. With regard to grant of the mining lease.
No, that is in relation. You have to just borrow and
My,
borrow and
my,
I would say the legislative objects. Whether your contention is that at the time relevant point of time,
Right.
made an application,
my,
it was a major mineral.
major mineral.
And therefore, the adjudication has to be made on the basis of the rules which they prevalent.
My,
I understood, sir. That is what I am asking or drawing your attention to 66. There are two ways of keeping those repeal rules to apply. Either by virtue of section 6 of the General Clauses Act or by virtue of a special reference into the subsequent enactments. Preserving or protecting that particular right which emanates from the repeal the rules.
my,
It's none. If it is none, then what? Can the repeal rules be said to be alive on the date of an adjudication? If it is not alive. The only provision is Rule 66, which talks about the old one,
my,
which was minor, becomes a major.
my,
Then in that event, it is to be treated in what manner?
my,
Just the reverse of this. It was major, declared minor, now re-declared as major.
my.
So, then what is the law? What to do? How to apply which law will be applicable?
In view of
That's the- So what law will be applicable?
And I also duly filed my revision application before the government of India. My. That was returned.
That is return is under what provision?
Because at that moment, my lord,
Under the old repealed rules,
I,
what will happen? After the old rule is repealed. And there is no saving clause.
and my lord, when the rule was repealed, my lord, 10 to 2015, my lord, 2004 rules was in force, my lord. Minor mineral concession.
See, that is what I'm saying.
My lord.
When you make an application, it was already repealed.
My lord, in fact, my lord,
Already repealed.
my lord,
And there is no saving one.
my lord.
In that event, what is the law? Tell us.
Now, in rule 2004 minor mineral concession rule, my lord, that there is no provision for lapsing, my lord.
Sir, that is what I'm saying. Sir,
Right.
you are claiming a right under the repealed rules.
My lord.
And that right is claimed when that act has already been repealed. Then
Yeah.
what is the effect? Tell us. Will they decide as if the repealed rule is still alive? Or they have to decide on the basis of a rule which is in vogue on that day?
But the review application, after it was returned by the central government, he made an application before the authority invoking 46(1) of the 2016 rule only in 2020. That is there in the order.
That is what I'm saying.
So obviously the authorities have acted in terms of the rules 2016, and the lapsing order, my lord, was passed way back on 15/10/2015 by the state authority.
So on the date of 15/10/2015, my lord, the rule 2016 was not enforced, my lord.
But you immediately, then immediately he should have filed a review.
If I suppose pending adjudication, the rule is repealed, then what would be the impact on that particular proceedings? You are talking about a thing that I made an application or raised an issue when 2016 did not come into force.
Ma'am.
But during the pendency of that application, it has come into force. What is the effect? How it will impact the pending applications? No, no, no.
Kali grandson, ma'am.
This will go and apply in this case.
Ma'am.
Once. On the general clauses act.
My lord, the lapsing procedure was inserted in 2018 of the 2016 rules, subsequently amended. In the year 2018, there was no provision for lapsing. And at that moment, my lord, they have passed an order with regard to lapsing my lease, ma'am. But my lease is valid. Grandson, time, sir.
Further upon this issue, now after 2 weeks, you
Right.
will see what it is.
Right. I don't-
When you will meet with the
The condition is they receive in the structure of the mines, that is quads and quartiles. Annex 1 is the demand is which is improved before the Annex 1 is the demand which is improved before the lordship. This demand was generated on the basis of the decision of the apex court in common cause cases. Miller, that common case is only applicable to the iron ore and manganese ore, not to other ores, Miller. And it is quartz and quartile.
ET of fact, was involved in causes the whole of the mine or the minerals.
Right, Miller, because here
How can you restrict?
Miller,
It is only iron ore and not
Miller, that has been clarified by your lordship in a previous petition. That has got no application here. Your lordship may kindly see in Himansharan Das case.
Then they are wrong. I think we did not read the judgment with that.
Your lordship may kindly see. There,
We will correct ourselves.
that your lordship can always.
Oh, this is not by any of us.
No, but by this honorable
You
court.
said that your lordship, so I was
No, this lordship.
Say this court.
Yes.
You should say this court.
We don't know.
Your lordship, then we treat it that we both are.
No. I mean, means this honorable. Yes.
This court.
Milord, your lordship, I can see. That has been clarified, Milord.
Where is the clarification?
Milord, your lordship, it is from para 6 onwards, Milord. In view of
Are applicable to case of other country.
106. 106 of the common cause judgment in lordship guidance. Para 106.
that they have quoted out.
It is applicable to all mining operations.
Sir, I have read this many times,
Yes.
that's why I adapted to it.
This Vimaichal of that case was also similar demand was raised. Basing upon the observation of the Honorable Apex Court in Common Cause. Respect of only excess production, not the violation of any other.
Is the point.
Similar matter, the state government carried appeal to the Apex Court. Apex Court, no, that is justifiable.
Which matter?
Well, that state government matter, that I have not brought, that is a WPC number 35008 of 2020. The state government challenge before this honorable court in many writ petition challenging the order of the revisional authority, holding that it is only applicable to iron ore and manganese ore, not in relating to other ores. That has been decided by this honorable court in 35008 of 2020.
Yes.
Holding that it is.
Then what happened against that?
Against that, state government satisfied by this honorable court judgment. Holding that.
Let me just saying so. That judgment is not available.
Lord, I have got a copy, Lord. I am handing over to my learned friend.
It is not reflecting that it is only restricted to
Where is
the order of fifth?
38415 of 2020.
Where is that order fifth?
That order, immediately I could not got a copy, Miller. That there, this honorable court decided. But that was challenging the order of the revisional authority holding the demand is illegal.
The order does not reveal that this point was taken and it has been appealed. But this is the judgment which you have relied upon, paragraph 6,
Mila.
very specific.
Mila.
Now we have to understand that whether it is in contravention to the observation of the common cause judgment or it is.
No, I will place that decision where my lieutenant also take instruction that was his instance 38415 of 2020 was decided by this honorable court. I am getting a copy for your lordship.
Getting a copy here and now.
38415 of 2020. Decided on 5th February 2021.
Yes, sir. Clear for 5.2. Yes, sir. Yes. Internal.
There is only a reference that it was relating to illegal mining activities in relation to iron ore and manganese in Mayurbank and Kyoto and Punjab.
Yeah.
But there is no positive finding that the common cause judgment is restricted only to iron ore or manganese ore. It's no meaningful whole.
Para 13.
There is no separate provision for the other kind of a mining than the iron ore or a manganese ore. Is there? I'm asking you, sir. Is there a distinct provision that for iron ore or manganese ore, this will be the provision for any other minerals? This would be the provision. I think the distinction is not there in the MODR.
The distinction only is relating to major minerals and minor minerals.
True. That is what is there only.
Quartz and quarters were minor minerals. So the provision relating to major minerals
will not apply. There is no difficulty. But one has to understand. Because addressing this issue, it's a pure question of law. Yes, does.
Impugned order, your lordship will find at page 30. First time. Yes, sir.
That is what we want. He's talking about taking items in the way of going. So that never the other.
This production, other than what is provided in the mining plan and the scheme and consent to operate. So that's 21.5.
There appears to be some gray area.
Yes.
Where the IBM has given a relaxation up to plus minus some percentage.
Yes.
IBM is the supreme authority after the amendment MMDR Act has come. If they come within that bracket, then what is the effect of it? And it is after the explanation is introduced or before the explanation?
The IBM only fixed
The demand is after
price of the mineral. IBM.
But there are certain, because in common cause I find there are different. But in that event, the IBM definitely can take a decision, a policy decision as well.
Grants me to stand like this.
So I'm going from common cause, there is an earlier one.
IBM. But here also from the impugned order, if your lordship will find, the price of the mineral per ton is as per the value published by the IBM.
So there's IBM has a
Multiple roles.
not only the fixation of the price, just to control the market so that there is no inflation is created, nor any shortage is created. They can also give a policy decision, giving a relaxation. I think the 20% bracket was given.
Actually, some time. This is the order of 2020.
Because what I gathers from the common cause is that because once you extract the mines, you do not know how much will come out. Yes. Sometimes it will be less, sometimes it will be more. It all varies. A big chunk that fell, you can't keep it there. The second figure is the option we consider. Some doubts. Yes, because I will try that. So I don't know from manganese and not other one. I can find a distinction between a major and a minor. But MMDR does not talk about any major or minor.
Yes.
So far as section 21(5) is concerned. It simply talks about any minerals. And minerals is defined as all minerals except mineral oil. So it really evaporates that particular distinction. Major and minor.
I clarify that.
Please take pages.
Item 5.
In item number 5, there has been some development for which I need to seek some instructions from the client members. Adjournment be granted.
Item number 6.
The petitioner who is the lessee miller, he challenged the demand notice under Annexure 1. It is issued for under Rule 32 and Rule 33 for demand of royalty miller. So my humble principal contention is that the royalty cannot be miller demand in absence of any excavation and consumer of mining activity. So which one is basically Rule
So, sub-rule 1.
Sub-rule 1 read with 32, sub-rule 2, second proviso.
32.
Rule 32, all the lessee for minor mineral other than the specified mineral, there is also other than the sand coal, shall be liable to pay royalty or dead rent, surface rent, additional charges, amount contribution payable to the district mineral foundation, amount of contribution payable to the environment management fund, and fees for compensatory effort. Sub-rule 2, my lord, second proviso, provided further that where the lessee becomes liable payment of royalty for minor mineral, any minor removed or consumed by him, and that is also my lease condition. I have to pay the royalty from the only consumed, my lord. That is also lease condition.
3315.
3315, your lordship, that is
Correct account of
similar. This will apply only post below consumption of the minor mineral. So the demand, my lord, my humble submission, my lord, this was since royalty only payable when there is a mining activity, operation of mining. In absence of that,
liabilities are dead rent.
yes, even they did, but they have said, my lord, in the notice. Your lordship, kindly see the very, this is a very notice, your lordship, Annexure 1, I am permitted to submit. Demand notice for the deposition of outstanding due multiple financial years with reference to subject to above. I am to say that you are instructed to deposit the outstanding dues towards royalty.
What is the mining? What is the mineral?
Well, it is a sand coal, no? Sand. And other dues.
Yes.
Sorry.
Yes.
And your lordship, the notice, your lordship, kindly the serial number 1. How the miller? 2022-23, the outstanding dues, your lordship, 2,25,000. Number of days, number of days, your lordship, can you see 992.
How can you justify, madam? If it is only payable on a consumption, that is fine. According to your own, that you have kept the query idle. So you can only claim the other amount.
It's here the surface rent and dead rent is included. That's in this.
Quality you have kept.
Yes, and other dues
And then,
includes the surface rent and the dead rent. For the last 3 years.
Instructed to deposit the outstanding dues towards the royalty
Yes,
and
and other
other
dues.
dues.
Yes, ma'am.
My question is that once this amount income or includes the royalty as well, then I could treat that there will be a certain component of royalty.
Yes, it's prior.
How can you do that?
Well, it's prior to the execution of lease back in 2019. When it's a royalty along with all the amount as specified in the rule has to be paid. And then the lease had to be executed after that, my lords.
I
But
understand
yes,
that.
but at that time, what happened was the demand was not raised, but the lease was executed. So when the all the documents got transferred to the mining department, thereafter this when this error was noticed, the demand was
What
issued.
provision you can ask for a royalty? Under what provision you can ask for a royalty? It is only rule 32.
32, yes, ma'am.
That's what tell us the 32 postulates that no lease deed will be executed until the royalty is held.
Whether it simply says payment of royalty along with
Correct. He says that there is this liability that the lessee for the mineral, minor mineral, have been liable to pay the royalty and also debt. Contribution also for those accounts, that's the liability. Royalty, that they are liable. When the royalty can be charged, it is a 3350.
yes, ma'am.
3350 talks about. No, sorry, royalty can be charged. It is a second proviso to subroute
32.
Because subroute 2 say that for every year, he has to pay the dead rent and the surface rent
Yes, ma'am.
at the rate. So royalty is not included. Then second proviso. Provided where the lessee becomes liable for payment, becomes liable for payment of royalty. Becomes.
Well, that's what subclause 2 says that the lessee should pay to the state government every year dead rent and surface rent
That's all.
included in the lease deed and royalty.
And
Yeah.
royalty.
And royalty at the rate specified in Schedule 2.
True.
Yes, ma'am.
Then second proviso.
Provided for the
Provided for the
Becomes liable for second.
payment of royalty for any minor
Removed or consumed by or is assured. He shall be liable to pay either such royalty or a debt rent, whichever is higher.
Yes, ma'am.
So that's all. So what is the incidence of imposition of liable royalty? Is either the consumption or a removal by himself or an agent or a manager or an employee. Your first line is in the issued demand that you have kept the inquiry in idle. That
This is
means
fine.
you have neither consumed
Yes.
nor removed. Then in that event, whether the royalty will be attracted or I can understand the other components may be attracted.
And it's to this extent, I obtain instructions manuals further the CPO which has to be obtained by him from the concerned authority that has not been obtained by him. He has been reminded time and again to obtain.
No, whether here is there, if he has kept idle, then you can go on charging the other one.
Surface rent and dead rent has.
Absolutely
Yes.
charge him. Who
Yes.
says? But how can you charge the royalty?
And it's to that limited extent manuals, I will obtain instructions and take time.
You are setting aside the demand, you are holding it, and we are saying that you recalculate the entire thing as per the rule 32. Dead rent is there. DMF fund, everything that is liable to pay. There's no.
It's one chance me if me kindly will give it. And just to that limited extent, my lords, regarding the proviso, I will obtain instruction. Why this amount has been obtained? Why
Want to
last
take
chance?
comment, but this is not expected from a member at that how the proviso or a legislative provision is to be interpreted. The authority will advise you or tell you that how to interpret.
Not regarding
It is
interpretation. my
your
lords, only
domain, but
regards
it
to
is your
inclusion of
duty
the-
to interpret the legal provision.
I understand, my lords. Only
Actually,
with-
you can take an instruction.
only with- Yes, with that regards, my lords, why the royalty as such has been included here. Only to that extent, I will.
Because it was kept idle, which is very apparent from the language. Royalty is attracted because you have kept the query in idle position. No difficulty. I have no confusion on facts.
What is this?
Because the language is very clear.
Because of lack of part of the petitioner for obtaining the CTO of
We are
that one.
supposed to understand the law.
Yes, ma'am.
Don't argue something in air which is not in consonance with law. It's try to understand. You may be defending the state. That does not mean you will defend with whatever the argument you make. It must be a logical and must be in consonance. I'm just simply asking. This is your authority has said royalty and other
Other dues. Outside
other dues be
to the rest.
price of their rent and all, which is important, which is logical. But royalty, then you have to recalculate. Nothing more than.
It doesn't specify.
Lease condition, page 56 provides the lessee shall has to extract minor mineration from the source as approved by the mining plan, that a royalty will be yearly fixed. That is also lease condition.
Yes.
Minimum amount of investment is specified in the notice and the amount of the royalty. Good calculation for this. The oral instructions which I received today morning, along with the agreement, the royalty amount which is to be paid, it was not collected at that time. So when the department was changed, that was included in this one simple notice, that and the dead rent and the surface rent. The royalty which was supposed to be collected at the time of execution of the agreement. So in one notice that was included.
We are taking this into account and we are putting our observations on such instructions.
Paying for just to confirm the minutes. So like obtain written and detailed instructions and praying for 1 week time limits.
Roman 27 Roman 4:3, he must not have complied because
Which one?
Rule 27, grant of query list 4:3, sub-rule
Sir,
3.
there is nothing which is reflected.
Yes, that is not reflected. Please.
Can you have, is she not aware that not aware of
Yes.
this?
It must be specific. It should be specific.
She is not aware of Mohinder Singh.
Yes, it should be specific.
You can't take any plea nor make an explanation which is not there in the
Cannot substitute by the open affidavit.
Supreme Court judgment is against consistent report. Authorities have taken shelter only under Rule 32 and 33.
Yes.
Not the. But the single board involved
VP list item number 7.
May I please your lordship, I am appearing on behalf of Senior Counsel Mr. Pathango. He is busy on another court, so kindly grant pass over.
Item number 8.
Adjournment for 2 weeks.
This is regarding extension of these balance. Extension of these is covered by an object judgment.
But my senior is not present today. That is the reason I am asking for my adjournment.
Item 9.
Kindly pass over. That's why I see it was on his legs.
Item number 10.
10 men on behalf of Mr. Vishnu and the adjournment. Therefore, adjournment.
Please. Item 11.
The lordship, the petitioner request for the withdrawal for the petitions.
Item 12.
The petitioner is the lessee. Lease period has completed on 18/1/2026. In between the lease period, an extra demand was issued to payment of royalty. Against that,
We want to dispose of.
yes, the lease period has been undertaken.
What is the, yes. Sir, I think you can't start this way. Where is appeal?
Well, Lordship, can I see annexure 14 for a moment?
Page.
Page 126. Yes. It's a notice which has been issued after intervention of this honorable court.
What's on?
Yes, Mr.
Yes, what are you doing? Or you are not disposing of the matter? Yes, write an appeal. You dispose of the matter.
I have received a copy.
Give me a copy here and now.
Copy is a mirror or automatic. Would you have to serve me a copy with it? Cannot be it.
How to come
A copy.
This petition is taken out by the petitioner. He is seeking a direction.
because
Earlier we came up,
yes,
it was said that expeditiously we dispose of money. And he because he received the notice, he said that it is infructuous. You are not conducted. He is saying that.
Item 13. 13, sir.
Maybe here the challenge of constitutional validity. A particular rules let's
So this to be adverted
let's
2 weeks.
Item 14.
Item 14, sir. Which really feels like it. Page annexed 1, page 11. I have approached the running, the relevant portion is para 40. Para 45 of that, due to some illegal extraction of the sand, I have approached this honorable court. In this honorable court, I have directed to take a necessary action.
So what is the prayer you are making? You are trying to quash the option which is going
My lord.
going
My lord, in this case,
three or already held on 23-1.
23-1.
Tell me, sir, that,
I have a my
difficulty is no translated copy. I can't read. I could read it.
and let it come to my para 9 of my writ application. Writ petition, my lord. That here in this case, the option notice was issued on 23rd 1 2026. This is Netai Jayanti. After that, 24 and 25 are holiday. 26th is Republic Day. And the option was done on 27th. So there is no reason and the time was not given to me to approach this authority to participate in the tender process. My lord. Here in this case, the person against whom I have alleged
When it was notified,
23, my lord.
23rd of
23rd of January.
January 2020.
My lord, page 76.
Why in haste?
no,
24 and 25,
Holiday.
the holiday, government holiday. 27, there was a the
Absolutely.
the SBI, they went on the strike.
5 persons participated, Miller. They all provided drafts from private banks. Now the auction is over. It has been settled in favor of the person. Work order has been issued.
And here in this case,
Work order has already been issued.
against whom I have alleged that they have illegally excavated the sand.
And Miller,
Why in
They
haste?
have
Miller, there is no haste, Miller.
If he does not have any account in the private bank,
My lord.
if he is an account only in the SBI, what he will do?
Miller, a draft was required to be Miller.
So who will prepare? The bank will prepare a draft.
On the
If there is an NEFT which is to be given, no difficulty. He could have done it sitting in his house.
In any case,
but I am also ready to pay the more amount. The option was made on 10 lakhs.
He has paid 10, more than 10 lakhs.
That creates a doubt,
My lord.
reasonable doubt in our mind why it was so done in haste.
Lord, if a private, if a bank is on strike,
He was said 27.
yes, Lord.
He was said so. All those days.
But then he could have approved saying that, my lord, their holidays are maybe permitted, my lord. He did not approve, my lord. He did not
Approved.
He could have approved, my lord. 5 other persons will have participated. Participated. He could have approved.
On the same day means 27/11, on the day when the
That was
option
the
is
day
made.
of the auction was held.
What do you say? That the bank is
As per my representation, the option notice was issued on 23rd, 24th, 25th holiday.
on your representation, it was issued on 23rd. What are they talking?
My lord, 27th I have annexed.
Please.
Sir, unless you give a translated copy, I am not in a position to read any of this. What I will decide. What is this?
And he would have requested to, because it was a bank holiday.
No, the request on 27th.
On 27th, the auction was held, my lord. By that time, we have not
When
participated.
the application has to be made,
Publication was made on 23rd. Public notice was issued on 23rd, my lord.
and when the date for making an application,
But that is,
what is the date for making an application?
but that is there at page 17, annexation.
What is the date? I could not read all those things, sir. Tell me, I'm relying on your statement. What is the date for submission of the application or a bid?
What do you mean?
Well, I do not know, I can't read.
Page 18, last 3 lines. ଦିନ ମଧ୍ୟରେ ସମସ୍ତ ଦେୟ ପଇଠ ନ କଲେ
What is the date?
27.
So, on 27 itself, we went and says that this is what a too short a time. And it appears 24, 25th is a holiday.
And the requirement is to participate to in the tender melon, we have to deposit the grant first. This is side one.
But my lord, see that, my lord, without going to that, my lord, now it has been less. My lord, work on it.
We don't to stay. You show
My lord, let them do.
No, sir, we will go stay everything.
And what have you done?
This is too high handedness which we have shown.
Yes, my lord, in that case, my lord, may permit to get.
No, sir, limiting the participation.
My lord,
What is the, Article 14? Plus, equality.
my lord, may permit me to get instruction. I'm sorry from the brief, my lord.
Page 30, what have you done? This is basically a writ.
Yes,
A writ was issued.
yes, my lord.
What have you done?
My lord, those materials were seized. Those materials were put to auction.
What state?
My lord, those materials which were seized pursuant to my lord's order, the Honorable High Court's order, those materials were put to auction. Pursuant to this order, those materials were put to auction, my lord. There, my lord, some persons were participated
On 6-1. Order was,
on 6-1.
passed on 6-1.
6-1. After that, the materials were seized. And they were put to auction.
When it was seized. When it was seized,
That, my lord, the petitioner himself has stated, my lord, may see
when it was seized.
23rd. 23rd, 1, 2023.
They have stated in the written.
And then once you are seized 23rd, you made an advertisement on 23rd itself for auction. Are you not aware that 24th is a Saturday and 25th is a hard Sunday? 26th January is a national holiday.
Then my
Are you not
lord,
aware?
my lords may
On
permit me to get
23rd, you deferred.
23rd.
23rd, you deferred it, see. I'm unable to.
23rd is the public notice.
They have to take the. But no, it's some. It's actually on 24. You did not know. That's what he is trying actually.
My lord, may permit me to get instruction.
Letter from 180, 23, विधान परिवार निम्न 24 तारीख को विधान को हजर किया because scheduled to be held on 24 March मतलब पहले दिखा कि हम तहसीलदार देखी और अनाज बहुत देरी में पहुंची गए जिलाधिकारी मैंने उपस्थित थे कागजात समिति जनाधारी लोगों ने जिला में अवसर द्वारा करीब 15 लाख बैंक का ऊपर लड़के को पानी दे जिला परिवार निम्न निर्देश और खिलाड़ी
So, my
on
lord,
24, you reached late. On
24th it was deferred.
Then the bank draft could not be made.
Then it
So
was
you fixed up
postponed to
on 27. There was a bank strike.
on only one bank strike, my lord. Only one bank strike. The other banks are functioning. I'm not on that, my lord. My lord may permit me one
that
to take instructions.
We are staying to take instruction. We are staying, then no further. But you do not permit anything to be lifted, it is for purchase or what?
Purchase price. And there is pay more amount, my lord.
So it has already been settled, my lord, in favor of a person. My lord,
Maybe
he
you
has-
have not given a position.
Yes, my lord, I do not remember that I-
One day before, they have some of the states assaulted the mining officer and the FIR has been lost.
I have
Oh,
questions regarding that, my lord. But let me see this. My lord, this is the
How many percent participate?
permission, 5%, 5%.
They are all in hand close.
This, my lord, this permission has been given to the, my lord, the person who was selected to, my lord, transport the material. This was given on first of this month, my lord. First of February, my lord. First of February. Sand, my lord. Auction sands. This permission was given on first of February. So, my lord, by this time already, my lord, he must have, my lord, transported, lifted or whatever.
Whatever it is, I am ready to purchase around more amount, 50
How
lakhs.
can that be?
If the sand has already gone, then what? What do you purchase?
They are not taken, my lord. As far as my knowledge, they are not taken.
When you have stated that
No, I am
they have
not.
not.
No, I am not sitting.
So take instruction, give it, tell us on day after.
Yes.
With the relevant documents,
Yes, ma'am.
come day after tomorrow, the relevant documents. Let us see.
And till now.
When they deposited the rest of the amount, how they have done, what is the order, everything, you will bring it. If they have not, then we'll see.
Whether the people transported the materials or not, that's.
Sir, they have to first deposit with you the entire amount which they have offered. Then you will have to issue the permission. This every documents have to, no, this is subject to the payment. Read.
Yes, my lord. I'll update. Yes.
Give the after tomorrow.
Item number 15.
I needed no assume.
It is already lifted, deflect. You can see for a competition, nothing over the at best.
The highest bidder for a chance error. Page 18, madam. Page 18 was chance error. And thereafter, between page 18 also can be seen. It is for 5 years.
This is the 2018, what you were doing.
Well, this I'm interested in. There are a lot of developments thereafter. And what happened, we deposited the dues, thereafter there was long, more than 11 months delay, 9 months delay for getting your environmental clearance. Annexure 2. Then, my lord, so certainly, they asked for some amount which are not there, part of the demand, related to present fire. That amount, certainly they changed it on page 24. They asked for from the 3482 lakhs. My lord, this amount was not related to some other fire, my lord. Some other fire, for which lease has been issued, granted in my favor. The merit thereafter I couldn't make it, they cancelled it. But after they cancelled it, they.
But what is your setup?
Sorry, madam.
What is your setup?
San Soirat is Subhadrapur. Subhadrapur. Kadjodi is Subhadrapur.
No, answer 4 says that. It is yours.
Kadjodi,
Kadjodi is Subhadrapur. That
which
is
is there, is 24.
Related to you.
Kadjodi arrest Subhadrapur.
This first paragraph.
San Soirat.
Second,
Yes.
third paragraph, you are also
Yes.
requested. You are also written.
For that reason also, but.
Kadjodi Subhadrapur.
But and also some other page. Page 23 also was done. But little bit development thereafter, therefore I am taking your worship to the subsequent facts.
No, you were declared as a successful applicant.
Yes.
And then was requested to deposit at 32 lakhs and all. So that is at page 33.
Yes, right.
24 is a demand. If they say that non-deposit may invite a non-execution of
They demanded to pay within 7 days, which was not possible because there is a funny super heavy cyclone and all that. They couldn't make a deposit. So what happened thereafter? They cancelled my lease. What happened? The second highest bidder filed writ application for this honorable court. Second highest bidder claimed that since highest bidder has been leased in grant in the set of first bidder has been cancelled, so grant me this lease. So this honorable court allowed that allowed that writ application and said that second appeal should be. But that was so I had accepted the fact that since second bidder Honorable High Court has already directed, so probably I'm not going to get because I am not party to that case. Thereafter, matter was again went to Supreme Court. Third highest bidder approached the Supreme Court.
Against the order.
Against the order of the High Court. And there was the order of this honorable court. That's all. Supreme Court set aside that the order of the judgment of the this honorable court.
Okay.
Yeah. But that was not within my knowledge. When I came to know that the Honorable Supreme Court has not stated that how to be settled, to with whom it matters to settle and all that. So when I came to know, I approached the authority because that land, that silence is still open. It has not been subsequent.
Let them go for
that kind of that now involve the now.
Let them go for a auction.
There is no such provision for now. The date now
cancelled and auction will remain cancelled.
So 25, as per amendment
E-lottery.
25 response, the e-lottery system has been introduced and competitive bidding has been completely abolished. So now everything will be done as per the e-lottery.
E-lottery system. Yes, that is correct, my lord. What I humbly submit that e-lottery system. The e-lottery system.
What is that?
The e-lottery system is that the amount will be fixed. Whatever revenue will be, the amount is fixed. So whoever will get the, let us say 10% will apply. Whoever will get the lottery, when his name will be there, he will get. Amount is fixed. That is much lower than the amount which was usually government was getting revenue in the tender.
The thing is this, I am also surprised with the very new notion.
Yeah.
That you have fixed the price. That would be the price. Nobody can quote above and nobody can quote below. And then whoever is applicant, he will go for a lottery.
Yes, that is the system presently. And
nobody is challenging that particular violation.
Item 13, where your lordship issued notice on the current advocate general, item 13, there the values of this technical.
It's a very unique process I have never come across. Inviting an open tender is to get the best price. And you have fixed the price under the lottery. Just imagine the lottery means what? How the lottery is conducted. What is the method or mechanism of lottery?
Para 18 category. I do not know the lottery system. I do not know how they will fix up the lottery. I do not know. But para 18 have figured how the government. My offer was 3 crores, much above the lottery price which has been fixed by the due fixed by the government. Para 18 I have categorically explained.
But so the difficulty is because your offer was cancelled. You did not challenge that particular offer. That is the staging and your
yes, that is true.
The second, the highest bidder, he came forward and there was an order. That order is set aside by the Supreme Court. Right. So he also goes out of the fray. Now, in that being the position, then what will be?
Now it is
you can't claim order of cancellation.
No. I had submitted representation to them that please accept all this, but I am ready to pay whatever amount is liable. I pay, and that amount will be valuable.
Cancellation has to be challenged because they have to recall the order of cancellation. What they will do with the cancellation? That is
that representation I have given merit.
What is this?
That is the gadget, that rule 25. 2025, the OMC rule has been amended, introducing lottery, the rule 27.
No, what is that? The lottery system into event there is a time in enterprise. But what she said was something very different than what the senior counsel is saying is a different. He says that you fix the price that beyond which you can't quote, nor below which you can quote. That means that everybody must quote that same price. And then
the additional
any applications which are filed those that the lottery will be conducted. What is what is the open tender process?
Yes, what is your?
The additional charge which we used to quote, that has been made constant. Everyone has to apply and they will get in lottery. The additional charge has been made constant.
Additional charge is something different from the other. But you have to quote the price of a sand.
My lord, what I quote, that is called additional charge. What I quote,
that is not an additional charge.
Yes, my lord, that is the additional charge.
This you are referring
under rule 32,
OMMC rules.
Under rule 32 of the OMMC rules, does not. It is in addition to anything.
No, my lord, as per the OMMC rules, there is a royalty component and there is an additional charge fixed.
I understand.
And whatever I have to quote,
2026.
Huh?
In exercise of power comfort under 21BA.
That is not there. He is quoting that.
To ensure uniform application, interpretive technique.
2026.
Fine.
Because
Yes.
No, this is the, I am talking about the notification dated 28th of November 2025.
Yes, I am referring to that one. Oh, sorry, it is 2 to 26. Operational guidelines, Annexure 10. I filed it Annexure.
I will proceed from rule 32(3).
That one of
in your brief it is not.
IA, we have filed it in IA.
32(3) also talks about additional charge.
No, that is what I am talking. Additional charge has not been defined anywhere.
It has
No, it has been stated in that, the Lordship will get it that IA 4876 of 2026. I have filed that IA. In that IA, I have filed the notification where they have clarified in 2nd February 2026. Operational guidelines. Annexure 10. Interpretation definition.
Definition 21A, 21B.
21, what it says?
21B.
Additional charge 21BA, unlike previous design, where there was a variable and bid component under e-lottery system, additional charge is fixed and statutory due. It refers to the amount payable by the selected applicant on a unit quantity of the additional drive, district foundation fund, payment, environmental management fund.
This is the amount which the successful bidder
Has to quote, man.
Has to quote.
Unless they fix a minimum additional charge, we have to quote about that.
No, that's not.
This is the, I do not know whether the amendment is brought because the definition is in.
No, they are
B.
21B.
But the operational page each, they are referring additional charges to 1E.
Yes.
What is this BA? From where is BA comes?
BA. Amended provision.
I do not know when
This is the new amendment provision. It says, means the amount payable
when that amendment is got.
on 28th of November 2025.
What is it? This is what we have. 28th November. Yes, just. After clause B is that remains the override. Says
They have removed the word successful bidder and replaced it with selected applicant.
no, as per they say as per the rate notified by the state government is added,
Well,
which was not there.
not there. And also the word successful bidder has been replaced by selected applicant. Will be selected through lottery.
It's a task, very unique way of describing it.
Just like Malas, the liquor is done in the state, it is just like that. The
No,
excise is
no, that should be
Operational guidelines are not like this. We had the industrial policy resolutions. Operational guidelines are framed under that. And sales tax matters, we have dealt many cases.
And language
Never before like this.
language is previous regime.
Operations supersede what is spelled out in industrial policy or policy resolutions.
And the statutory rule, that should not be use of the language previous regime. That regime.
So that's why I think Mr. Dale has challenged that virus. Item 13.
Item 13.
Because the government has the authority to fix the royalty, but now in this case they fix the additional charge also.
But now this is not your case. Your case is something else.
No, my case is that now, basing on this pilot, now
Nowhere in the
In this context.
I have simply requested the government to grant the list to me on payment of earlier rate, which was fixed at the time of tender.
Because he may come, he may not.
That I have requested the government to fix the grant Sarat at the previous rate, which is around 3 crore above the rate which has been fixed by the government.
Without challenging the order of cancellation.
Cancellation, my lord.
Challenging the order of cancellation.
I'll seek amendment, my lord, because my friends have not.
Cancellation is staring at your face.
My friends have not done it. Probably,
The order of cancellation is.
Because it's a lot of time has elapsed. That's the reason probably my friends have not done it. But they can file a amended application.
How many?
That's the only issue. I wonder
What was the rally was of which year?
This is 2018-19,
1890. And the settlement is done for how many years?
5 years.
5 years.
So the 5 years has also gone.
5 years has also gone.
And now
How can we,
But
how can we resurrect?
CA will take another 5 years now.
because
So
now government is losing revenue every day. Because now it has been left blank since all the years. I applied because it is lying blank.
It's very good because there will be a lot of sand which would be accommodated there.
So I applied, I represented the government because of that only. Because that is lying vacant.
Mr. Khan, consider one aspect because even if the normal period of the lease has
The normal period is lease is gone.
so
But
what now can be done? Because it is really kept in what would be the appropriate word? Medio, can I use it? Medio.
at least till they take a decision, at least they should consider my application so that I can operate the lease by paying them the rate which was much higher than the present rate fixed by the government. At least till they take a
Piece
decision.
of life to you.
That part the government will be getting revenue. Now government has released revenue since last more than 7 years.
Ago.
May I keep it request for also to keep it some other day? I'll try to find out something else. Some other day, Melod, next week, Melod, I'll try to find out some other day. Much appreciated.
Item 16.
Extension of query. Extension of query.
this period is over. Prior to that, she applied.
Item 17.
Some 17 minutes. I'm so glad. If I need some extension of time to leave the morum, the fact remains, annexure 1, the auction notice was issued.
Moron or a moron? What difference?
Minor mineral that is used for road repair.
There are two expressions I could, just wanted to understand.
The message is like that we are in local language.
Certain times it is Maram.
Yes, ma'am. And ma'am. Item 19.
Your Lordship, I have limited grievance for consideration and disposal of my representation. That is stemming from OMC's failure to respond to my representation, where I have sought. Yes, Your Lordship, I'm coming to that. I have sought a meager 3-day allowance, a 3-day extension to allow me to lift the pending balance quantity of materials. I am of iron ore